Welcome to the Macmillan Report. I'm Marilyn Wilkes, your host, and our guest is Kamari Clarke, Professor of Anthropology at Yale University and Chair of the Council on African Studies at the Macmillan Center. Professor Clarke's areas of research explore issues related to religious nationalism, legal institutions, international law, the interface between culture and power, and its relationship to the modernity of race and late capitalist globalization. Her recent articles and books have focused on religious and legal movements and the related production of knowledge and power, including the 2004 publication of Mapping Yoruba Networks, Power and Agency in the Making of Transnational Communities. Today we'll talk with Professor Clarke about her newest book, Fictions of Justice, the International Criminal Court and the Challenge of Legal Pluralism in Sub-Saharan Africa. Welcome, Professor Clarke.
Thank you. Thank you very much.
Please tell us about the premise of your book.
Well, Mapping Yoruba Networks was my earlier book, and in that book I attempted to think through how one would do an anthropology that goes beyond spatial configurations. In this book, Fictions of Justice, what I attempt to do is take on some of the same conceptual trajectories, but instead map them through legal frameworks, and thus the title, Fictions of Justice. It's an attempt to think about that which constitutes justice, to ask questions about the very things that seem to be natural and straightforward. Often when we talk about justice, when we say justice has been done, etc., we presume that we all mean the same thing, and the book really is an exploration over the controversies of justice, both transnational and national. I examine an emergent movement, the rise of the International Criminal Court, the formation of the court, as well as the contestations related to the making of the International Criminal Court, what we call the ICC.
Okay, what is the ICC and what countries fall under its jurisdiction?
Right, yes. Well, the ICC is known to most as an independent international judiciary. So it has the teeth of a court, as one would expect it. There are 110 countries that are member states that are under the jurisdiction of the court, countries from every part of the world, really. The U.S. is not a signatory, but there are a number of countries, many countries that are, more than half of the world's nation states are under the jurisdiction of the court. Okay,
and why focus on Sub-Saharan Africa? Why did you pick there?
Well,
that part of the world?
Yeah, well, I'm an Africanist and I'm also an Americanist, of course. And so in many ways, analytically, it made sense for me to examine what was happening in this region vis-a-vis the, why states sign international treaties and why this treaty in particular. But some of the decision-making really wasn't mine. The first cases are African-based cases. They're not China-based cases, they're not Latin American-based cases, they're African-based cases. So it was also quite straightforward that, yes, indeed, I followed the cases more than followed my own research areas.
Okay, so the term legal pluralism, what is it, and what is the challenge in Sub-Saharan Africa?
Right, yeah, that's precisely the subtext of the book, The Challenge of Legal Pluralism in Sub-Saharan Africa. Well, legal pluralism is somewhat of a new concept, I guess a 20th century concept that emerged out of an interest to think about dual legal systems that coexist. And a lot of legal scholars, legal anthropologists, a range of critical legal theorists, etc., have used it almost as a way to go beyond a term known as relativism, right? So to go beyond relativism, but to think about the ways that systems coexist and compete. My argument, or part of the premise, is that we have to go beyond this conception, beyond the notion of plurality, that legal systems coexist. The challenge is that these systems coexist in relations of power. They coexist alongside other negotiations that are connected to other powerful, very powerful institutions, the World Bank, the IMF, powerful nationalist movements, etc., and to simply see them as legal systems that exist in and of themselves without looking at systems of hegemony, the ways that these systems work in relation to other spheres of power, is to misread the coexistence of legal systems. And so the attempt is to not only look at these legal systems alongside each other, so the rise of Islamic Sharia in northern Nigeria alongside the emergence of ICC power, right? It's to go beyond simply looking at the dualities and instead to think about what are some of the other dynamics that are at play here? What are the power relations? Why are states signing these treaties in the first place? So really the attempt is to go beyond simply this comparative frame and to think about the power relations that sometimes imbalances complexities that are fundamental to the so-called coexistence of these legal spheres.
So what methodology did you use in your book? How did you gather the data?
Yeah, it's a good question, actually, and my methods were somewhat unorthodox in the sense that I'm a cultural anthropologist who is interested in international relations, has some background in political science, and the methods that I use in their ethnography, it involves doing ethnography, but it's transnational and multi-sided ethnography. It involved, in your most orthodox way, doing interviews, of course, doing focus groups, doing standard observations that any social scientist would engage in.
Okay.
But it also involved late nights after a diplomatic hearing, a closed session at the bar, having a few drinks to hear, to debrief on what the latest controversy was at a given meeting. Or it involved me going to law school for a year to learn the fundamentals of criminal law and some basic legal jurisprudential questions. It also involved working with NGOs in various parts of Sub-Saharan Africa, so doing some constitutional reform work. So some engaged, what we call engaged ethnography, which goes beyond simply data collection, but also participation and engaged political mobilization related work. And that is often seen as a less orthodox approach, but I tell you, this kind of work, this kind of transnational, quite messy work that examines an emergent movement that has many tentacles in many different places, involves quite messy methodology. So those are the highlights of the work.
Something just dawned on me when you said, you would go to the courtroom and then, afterwards go to the bar. It dawned on me, where does the International Criminal Court travel around to different countries based on the trials they are hearing, or is it in one location?
Right. Well, the court, the building, the structure, the thing called the International Criminal Court is in The Hague.
Okay.
It's just, it's in The Hague. It's in the Netherlands.
Okay.
But before it was in The Hague, the court was really an idea. 1998, the signing of the Rome Statute led to the concept. And from the concept, there were preparatory committee meetings at the UN. So every couple of months or every 4 months or so, diplomats from around the world would converge to work on this document that then became the International Criminal Court, that became the constitution that was fundamentally the constitution of the court. So it was an idea that became a building, but still it lives outside of the structure. And I think that's what is quite interesting and phenomenal about this movement that exists alongside the rise of the rule of law around the world, really. But yes, in a straightforward way, it is a building, and it's a building that houses many, from the defense prosecutor to the lead prosecutor, to the judges, to the audience, the people who visit and watch the cases. It is a building that's housed in The Hague.
Okay. Let's talk about your findings. What conclusions have you reached? Tell us about some of them.
Well, there are a number. The conclusions are two-pronged in some ways, because I'm writing to multiple audiences in this book, and it's quite the challenge. On one hand, I'm writing for anthropologists. I'm engaging notions of legal pluralism. I'm thinking about transnational methodologies, how one studies up, as it were. Historically, anthropologists have tended to study local people in a way in villages, etc. And this has changed tremendously over the last decade. And so I'm in conversation with anthropologists thinking about the limitations of this concept called legal pluralism, thinking about the fictions of this notion that we know as justice, and trying to shift the debate in a way to push us to think about emergent movements and hegemonic movements, movements that are fundamentally intertwined with a whole set of other new and emergent legal institutions. The other is I'm in conversation with NGOs and with sort of governments and with the prosecutors and lawyers and human rights activists who are part of the court. And in part, I'm asking them and thinking through this idea of justice, but also thinking about the methods of deliberation, right? How might we envision a different world and a different constitution or a different statute? What are the problems of the contemporary statute? What kinds of conversations do we need to be having in order to think through what justice might mean in these other domains, these other locales? This is all part of a conversation, an ongoing one that I have and am having with them. It's not always a popular one. My position isn't necessarily a popular one among NGO activists, etc. But it's an important one. It's certainly a conversation that needs to be had.
And then lastly, what is the most surprising thing you found in doing the research for Fictions of Justice and writing the book?
Yeah, the most surprising. It probably was how different people's definitions of what justice is are. One person's justice is another person's retribution. One person's justice is another person's pain. And I actually thought that I perhaps was had a sense that there was more in common than not. And after almost 8-9 years of research in this area, I realized that this concept is a concept that is quite far-reaching and is fundamentally culturally constructed and means everything and nothing to the very same people who are being asked what justice is. So that's probably the most surprising.
Okay. Well, thank you so much for being here with us today and sharing some of your research.
Well, thank you for having me, Marilyn.
For more information about Professor Clarke and her work, please visit our website at yale.edu/Macmillan Report. Be sure to join us again for another episode of the Macmillan Report, made possible through funding from the Whitney and Betty Macmillan Center for International and Area Studies at Yale.